I would like to ask her who sent that and what judge signed the PPO paperwork that you claim to have, because we can find nothing on me.
I never claimed to have paperwork.
So
where are you getting that from?
Who said that there was a PPO out on me?
It actually, after more investigation, they said the police officer told you to stay away from that person. I've also have numerous messages of neighbors saying that you're threatening children at the park, threatening the neighbor with a baseball bat. Cops were called several times. So I'm going by, I live 3 hours away, Anthony. I'm going by what my neighbors are telling me. I submitted it all to the court as well.
Okay. So you're going by what your neighbors are telling you. Are you going by what your renters recording are telling you?
Have you sent me any recordings? And as far as the intimidation as well, I did not know Travis was Chexie. And I didn't know Chexie was the person you had a problem with. And I did not know Chexie was going over there to cut the lawn. Don said he would cut my mom's lawn for her.
Your Honor, I would like to bring up actually some evidence I submitted.
Okay, this is the time for you to ask Ms. Matthey questions, okay?
Okay.
And you'll have a chance to present your evidence after that, okay? So do you have any more questions for Ms. Matthey?
Yes, I do. Ms. Matthey,
Okay.
do you remember not saying, hey, what's your post on about Facebook? I kicked Chexie and Cameron off the property for trying to get Mitchell to drink. Are they the ones harassing you? Did you or did you not say that?
No, I do not remember that. And Anthony, again, I don't understand why all of this. I need my house back so I can sell it. It's plain and simple. We're all affected by COVID.
Okay.
It's my house. I need to list it for sale.
I have
You've
two
known
more
this for 9 months. What does this have to do with the lease has been up since
Okay.
October?
Okay, hang on, Ms. Matthey.
I have 3 more questions, Your Honor, and then I'm totally done with her. 3 more questions.
Well, hang on. Okay, hang on. Okay, Ms. Matthey, if you want to testify again, that's fine. I'll let you respond. But right now, I just need you to answer Mr. DePeel's questions, okay? So, and again, I know tensions are high here, but we need to follow the proper procedure. So, okay, Mr. DePeel, what's your next question?
Okay, she said no, she didn't send that. So that would also be safe to assume you didn't say in a Facebook message, and I quote, "Oh my God, I didn't know Trevor was his real name. I always knew him as Chexie. Anthony, be careful. They are dangerous. That dangerous drunks that I begged Mitchell not to hang out with." It's safe to assume you're also going to say you didn't say that. Is that correct?
I honestly did not know Trevor was Chexie. I did not. I know him as Chexie. I have not talked to Chexie since I lived there.
Okay, hang on. Mr. DePeel, I don't know who Chexie is. I don't know who any of these people you're talking about are. What does this have to do with whether or not you got notice to quit, and whether or not you should be evicted?
I have one quick question, Your Honor, and it does have to do with that. And okay, did you accept rent in April after giving me notice, telling me that you would like the utilities off or in my name? Or I'm sorry, let me rephrase that, Your Honor. In this past April, did you knowingly accept rent after telling me you wanted me to move?
A deposit in my account, rent, utilities. I just said that in April was the last rent you paid or a deposit that you made. I mean, put it towards the $5,000 you owe in utilities.
So it was after whatever
Oh.
notice you say you sent, it was after that you accepted rent.
It's not
correct?
notice that I say I sent. They're all stamped from the court. All three of them, Anthony. You
So
were
you
served
never
them.
personally sent the notice. You just went to the court. You went straight to the court.
That's what the court told me to do. It had to be served. Yes.
No more questions, Your Honor.
Okay. Ms. Matthey, would you like your 24 pages?
It's about 24
The
pages.
24 pages of exhibits you submitted to the court admitted as an exhibit?
Yes, please, Your Honor.
Okay, so we'll go ahead and do that. And hang on a second. Got it. Okay, so. All right, I'm going to take a couple of minutes to look over Ms. Matthey's exhibits because I did not have those available. And I want to see if there are any questions I have based on those exhibits, okay?
Yes, Your Honor.
Oh, no.
So we're on the record in here, you know.
I did not know that.
So when, are you guys moving in to start working on that this
No,
afternoon?
no, I was just gonna come in and, swipe a ceiling tile. I can do it later next time.
Okay, should I confine you when we're all set?
Certainly, we're gonna go to the hearing room over here and start installing that system. Because we're done.
Okay. I will let you know, we are in the middle of the case.
Don't
so
go them.
we'll just break. But then we have one more hearing after this.
Okay, it could even happen any day.
Okay,
Not that-
all right, sounds good.
Thank you.
You're welcome. Do you need me to get the door for you? Not at all.
Thank you so much. Or slightly.
Mhm.
All right, we're back on the record in Matthews versus DePeel. I have had an opportunity now to review the records that were submitted by Ms. Matthews. And Ms. Matthews, the first exhibit you submitted, that shows the amount of rent that you believe was paid and based on your bank records, correct?
Yes, Your Honor.
All right. And the second exhibit, bank statements. Those are the bank statements that you reviewed to show deposits of money made by Mr. DePeel for rent, correct?
Yes, Your Honor.
And exhibit 3 are the text messages you referred to where neighbors complained about Mr. DePeel calling the police on a regular basis and generally upset about his behaviors.
Yes, Your Honor.
And exhibit 4, same, I'm sorry, that was exhibit 4. Exhibit 3 is the message about the utilities from December 28th, 2020, indicating an agreement about transferring the utilities to Mr. DePeel's name. Correct?
Yes, yes, Your Honor.
Okay, and let's see. Now there's exhibit 5. It says breakdown of rent. Oh, exhibit 1 was the signed lease agreement. Exhibit 5 was the first document I referred to, the breakdown of what rent was paid. Okay.
Yes.
All right. So I am going to admit those. And do you have any other evidence you wish to present?
No, Your Honor.
Okay. So, Mr. DePeel, the case now turns to you, and would you like to testify?
Yes.
All right, raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
All right. Can you please state your full name and spell the last?
Anthony James DePeel, D-E, capital P-E-E-L.
All right, and Mr. DePeel, you're the defendant in this case, correct? Was that a yes?
Yes, Your Honor.
It was-
I shut my
okay,
video off
and-
because I had lag issues.
Right, okay, and you're not disputing the rental agreement. That's, you admit you signed that on October 25th, 2019. $850 a month rental, correct?
Correct.
All right, now Ms. Matthew indicated that even though it doesn't say that it's a 1-year term, that's the term that you had orally agreed to, correct?
No, that is not correct. That was part of another deal.
All right, so what was the original term? How long did you anticipate being there, and did you have discussions with Ms. Matthew about that?
We planned on buying this place, and yes, we had discussions with Miss Matthew about it. As you can see from the messages I submitted, she contacted me wanting to sell the place, get out from her land contract that she had with her mother. That's what she told me and my girlfriend. That after the first year, that, and this is why it rents at $850, she wanted $10,000 down on a down payment. Well, if you take $10,000 and divide it by 12, it's a little under $850. She offered to cover all utilities as long as $850 a month was paid. Well, come the 1 year, she backed out of the sale, yet still wanted me to put the utilities in my name. I did not feel comfortable with that at all, at all. And we basically got caught in a holding pattern there. She had a bunch of items stored here that I told her either get out or pay storage. As you can see from the messages, she also knew that was how I needed the space for my income. I'm a medical marijuana grower. She knew that even before I moved in. In fact, with the messages I submitted to the court, it was her idea that I used the garage for a medical marijuana. So we have been stuck in this holding pattern with a garage full of stuff and her making dates to come up and get it, and then either saying her son bailed on her or just not showing up. Well, things went to hell in April when I told her either pay up or I'm getting rid of the stuff. You can either pay it and come get it, or you can abandon it and I'm going to go after the disposal charges. She's like, no, that's fine. That's fine. How much longer do you guys plan on being there? Well, May was hell. Halfway through April, we're pretty good. I don't know. You know, we're kind of in limbo here with this whole COVID. Oh, okay. Are you going to deposit rent? Yep, deposited rent. And I thought that's where things were cool. And then 2 weeks later, we get a cop showing up. If it's not one thing, it's another. It's always going back on something that, though you can prove was said, it's the total opposite with her. And it got to a point with rent. I don't care what you want, Michelle. If you're going to shut my power off illegally, if you're going
Excuse
to
me, Mr. DePeel.
I'm sorry.
You're not to refer to Miss Matthew, okay?
I'm sorry.
You're to direct all your comments to the court, okay?
Yeah.
Thank you.
I'm sorry, Your Honor.
Go
I
ahead.
was saying it as a quote. I wasn't directing. I'm sorry, but I'll keep that in mind. I apologize about that. I really do. Yeah,
That's fine. No worries. Go ahead.
It just got to a point where I said, okay, I don't care if you're going to shut the power off. Let's take it to court then. You didn't properly notify me. By your own lease agreement, you're supposed to notify me in writing, which you didn't do. You purposely played me, as you can see with the messages, till you got rent money. Then you let me know you were evicting me. And other than that, Your Honor, we thought we were going to live here forever. This was supposed to be our home. Like, truly, it was supposed to be our home. It was supposed to be the stop of this damn cycle of coming to court every 2 years, fighting eviction because some slumlord wants a better buyer. And let's be honest, COVID prices suddenly jumped property value, and now she wants me out, but isn't going for money. It's wrong. This is all wrong. And by law, it's wrong. Her own lease, she has to give me 14-day written notification. Messages while accepting rent and stringing me along is not notification. I'm sorry. That's all I got to say.
All right. Ms. Matthew, do you have any questions for Mr. DePeel?
I do not.
Okay. All right. Do you have any additional evidence you want to present other than your exhibits? I will admit those as well, Mr. DePiel.
Yeah, sorry, my internet cut out for a second. I'm sorry about that.
All right. So Defense Exhibit 1 is a letter addressed to the court that pretty much is similar to the argument that the defendant has made today. And then there are some text messages back and forth between the defendant and the plaintiff. Several pages of those. And I'll mark that as Exhibit 2. All right. Well, I'm going to dispense with closing arguments. So I think it would just be a repeat of what I've already heard in the statements or testimony that's been made, which was a combination of both testimony and argument. So anyway, the plaintiff and defendant signed a month-to-month lease back in October of 2019. The rent was due on the 18th of each month. And apparently that went well for about 3 months. And at some point, well, after the 3 months, the defendant stopped paying rent. It was sporadic. There were payments, but it was not the $850. It was $500 generally, and sometimes it was nothing. And that's documented both by the bank records that the plaintiff submitted, as well as the Exhibit 5 plaintiff submitted, which is her own summary of what payments were and were not made. There were statements back and forth about terminating the agreement, and when in around January of 2021 or December of 2020, there were discussions about transferring the utilities to the defendant because of the lack of payment of rent, which according to Ms. Matthews is now about $8,000. Ms. Matthews did not bring this suit for the purpose of recovering the money. Apparently, she's written that off. She's requesting possession only. She says she needs to sell the house. Irregardless of what the intent is, the lease agreement only requires, because it's month to month, even if there was the 1 year period where the parties had agreed, and I were to accept there were an oral agreement to have a 1 year lease agreement, which I do because Ms. Matthews admits that, that would have expired in October of 2020, October 25th to be exact. And after that, any rental agreement was monthly only. Accepting rental payments does not change the nature of the lease agreement as being month to month. And a notice to quit was filed with the court on April 8th. It was served on the defendant, and acceptance of April's rent does not change anything because the rent wasn't due until the 18th of the month. And so the notice was properly served according to law. There has been no defense to that. that in some way the notice
Literally
was
said she didn't
invalid
serve
or?
me right. How is there not a defense right? Her own words, she said she didn't serve me right. And you're saying there's no defense to that?
Okay, Mr. DePiel, I've muted you because this is my ruling. You've had a chance to present your case, and now it's my turn to rule. I have to make a decision. Okay, and frankly, your behavior right now is consistent with the statements of your neighbors who complained about you. Now, there were numerous reasons why Ms. Matthews wanted you evicted. One may be that she wanted to sell the home, but certainly there were complaints by the neighbors, according to the text messages, and police had been called out numerous times, and Miss Matthew had had enough, as well as being $8,000 short in rent payments. So there were numerous reasons. Mr. DePiel, I'm not sure what kind of sign you just held up. I couldn't read it, but, oh, okay. All right. Well, I appreciate that fact, and I understand that it's not a simple thing ever to be evicted from a home. But anyway, there is no defense in this case that would support this court not entering a possession judgment. So I'm going to do that. All right, Mr. DePiel, your conduct is very disruptive. And I'm going to remove you from the hearing in a second here if you continue. If you want to continue to hear what the court has to say, then fine, but you need to conduct yourself as if you were in a public courtroom. All right, so the court will grant a possession judgment. The defendant has 10 days to move out, or the court will sign an eviction order that would allow the sheriff to, or a court officer to assist in the eviction process. And Ms. Matthew, you'll need to file that additional paperwork to affect the eviction itself if Mr. DePiel does not move out within that 10 days. All
Yes,
right,
Your Honor.
Mr. DePiel is continuing his disruptive conduct. So at this point, I'm going to remove him from the meeting. And I think that's the end of the ruling anyway. So we're all set for today. And Ms. Matthew, you'll be able to get a copy of my order from the court. They'll send that to her anyway, won't they, Carol?
Yes.
Okay, so you'll get a copy sent to you, or if you want it sooner, they may be able to fax it to you or otherwise. And you can ask them also how to perfect the eviction if Mr. DePiel does not move out. And given his behavior in court today, I don't expect that he's going to move out.
Oh, no, it's not going to be nice. No, I definitely am going to have a problem, so I will definitely file that paperwork. Thank you, Your Honor.
Okay, thank you. We're all set for today.
Thank you, Your Honor.
All right, so let's go to our last case of the day, and Ms. Tarbutton is here. For that one, this is Source One Capital Incorporated versus Elise Tarbutton. And
Your Honor, I'm representing Source One Capital. It's Source One Capital Incorporated versus Larry Barnum.
oh, that's why I'm confused, because my paperwork on the summons, it says Source One Capital versus Larry Barnum.
Yes, that's
Or
correct.
I'm sorry, versus Elise Tarbutton with plaintiff's attorney Larry Barnum, but this is Source One Capital versus Larry Barnum. Is that correct?
That's correct, Your Honor. I don't know.
Okay. I didn't think you were being sued, but
Not that I know of.
okay. All right. So Ms. Tarbutton is here on behalf of Source One Capital.
That's
And so anyhow, it doesn't appear that well, maybe Mr. Barnum is here. There's someone at 231-676-9092. Who is that?
That is my client, Your Honor. That is Brian Ritt. He's here for Source One Capital Incorporated. He's my client.
Okay. And it's Brian Ritt.
Correct, Your Honor.
Is that okay?
Yeah.
Yeah. All right. Good afternoon, Mr. Ritt. Let me just check our participants list to make sure there's no one else on the call. No, there is not. So let me see. This was a service alternative service case.
That's
And
correct,
so
Your Honor.
you're looking just to recover possession at this time. Is that correct?
That's correct, Your Honor. And I do have all of the information summarized if the court would like me to summarize it. We did alternately serve Mr. Barnum by publication in the Antrim County Review, and I did provide, I believe I mailed it in to the Antrim County District Court, a affidavit of publication of that alternate service. I mailed it in on July 9th. Of 2021.
Okay. All right. So what relief are you asking for today then?
We're asking for possession of the property. This is a land contract forfeiture. The land contract began in August 2019. Mr. Barnum made 2 payments for August 2019 and September 2019. The sale price was $12,900. There was a down payment made of $5,000. There were
$500.
$500. Excuse me, Your Honor. Thank you, Mr. Ritt. There were 2 payments made. And I believe those were for $300 each. Total, excuse me, $150. Each installment payment was $150 for a total of $300. So after that, there was a balance of $12,100 due and owing. With interest, with my interest calculations, I have it calculated that Mr. Barnum is currently $368.48 behind. That's installment payments that are due. That would be 22 missed installment payments and $68.48 in extra interest. Other damages that I have are late fees. The land contract did include late fees. Those were $25 each month. So 22 months of $25 late fees is $550. And additionally, Mr. Ritt did pay, or Source One Capital did pay property taxes on the property for 2020 and 2021. The total of those property taxes is $124.86. And then Source One Capital did have costs in pursuing this complaint. For possession, there was a $55 filing fee. There were 2 $20 motion fees. We had to file various motions in this case, one for adjournment, one for the alternate service. We did attempt to, obviously we made various attempts to locate Mr. Barnum. And so we did actually do an iChat search to try to see if, he was in, his criminal background would give us an idea of where he may be, which was another $10. And then the publication fee for the alternate service was $243.25. So I have as far as on the proposed judgment, which I did email to the district court this afternoon, as well as Ms. Myers in Antrim County. I have, for the amount, $3,368.48. Other damages, $674.86. Cost, $348.25 for a total judgment for redemption purposes. The total amount would be $4,391.59. This land contract, the balance, more than half of it has not been paid. So we're asking for a period of redemption of 90 days.
All right. I'm just taking a look at the order here. All right, well, do you see that order, Ms. Stockton?
I have not looked.
Maybe
I
need to
emailed it
refresh it.
to district court at 86districtcourt.org.
So I can get that to you right now, Judge, because
Okay.
She may not have worked it, but I would, if she emailed it there, I would have gotten that.
All right. All right, well, if the order is represented, I'll go ahead and sign that. I would note that for the record that it is 2:57 p.m. Defendant has failed to appear. There was alternative service provided, but apparently all attempts to locate Mr. Barnum have been ineffectual. So it's now nearly 3 p.m. and no Mr. Barnum. I've got a copy of the order in front of me
That is
right now.
two-sided, sir.
So I will go ahead and sign that.
And just to
And-
clarify, Your Honor, there should be what I have written as addendum A, the legal description for the property that would be on the second page or the second side of the judgment.
Yes.
Okay, thank you, Your Honor.
Okay, so the order has been signed. You can get a copy of that from the clerk's office. They'll send a copy to you. And we're all set for today unless there's anything else for you, Ms. Tarbutton.
There is not. Thank you, Your Honor. I appreciate it.
All right, thank you. And thank you, Mr. Ritt, as well.
Have a great
Yes,
day.
thank you.
It's a public courtroom. I can ask questions, so I'm going to ask the question. How can any